Senate Majority Leader Mitch McConnell reacted swiftly to the news of Scalia's passing. In fact, he reacted within minutes, McConnell saying that the people should have a say in choosing a successor to Scalia. In other words, the Senate should not confirm a replacement on the Supreme Court until after the 2016 election, the new president. But will it play out that way? And by the way, who on the court right now can fill the void left by Scalia? Joining me now from Columbus, Ohio, State Director of the Convention of the States Project, Steve STECHSCHULTE. Steve, you talk about Scalia, what a legacy. An originalist, maybe the greatest originalist to ever sit on the bench. And now that's what this fight is really all about. Do the folks on the Supreme Court, the remaining 8, receive a colleague who is like Scalia, or is in the image of Barack Obama and similar to the 2 appointees that he's already put on the Supreme Court? That's what this fight is all about right now.
Well, you're exactly right, Graham. Justice Scalia was a tremendous defender of the Constitution. And I think Senator McConnell has a duty to call the Senate into session and not go into recess until after the election, because the Supreme Court appointment has ramifications over the next 20 or 30 years. And there is no way it should be made by a recess nomination. And
Obama, we know him. He shows his hand. He's already said he's going to nominate someone, and he'll have a backup to that and a backup to that one. So the Senate needs to be ready. And I'm talking about the John McCains of the Senate and Lamar Alexander and Lindsey Graham. Don't buckle to make it look like you're getting along with this president, to make it look like you're, quote, bipartisan. This is bigger than that. It's about our country. It's about our Constitution. And they have to do everything in their power to block a nominee by this president. And, you know, the framers of the Constitution knew what they were doing. This process, like the impeachment process, is political in nature. So they have every right to do that.
That's exactly right. It's time for the Senate to stand up for the people of the United States through their powers given to them for advise and consent through the Constitution. And now's their opportunity to stand for the American people.
Okay, so McConnell has said that he is going to stop any nominee by this president to the Supreme Court. And he was very swift to do so. And there is precedent for this in terms of the United States Senate stopping nominees by a president in his final year. It started with John Quincy Adams, and most recently it fell upon LBJ. They made nominees that were rejected by the Senate. John Tyler, President John Tyler, had the worst record in terms of filling vacancies on the United States Supreme Court. One vacancy went 424 days, the other 835 days. There have been, as you mentioned, Steve, 12 recess appointments to the United States Supreme Court in the history of this country. However, it should be noted that these recess appointments serve only until the end of the current United States Senate. So it is crucial that Mitch McConnell holds firm here and does a pro forma session of the United States Senate. And that is, to define it loosely, pro forma means that the Senate technically is never in recess, and that's fine for the next 330, 340 days.
That's absolutely correct. And it's really not unprecedented for the Senate to make its wishes known to not confirm someone at a time like this. In fact, in 1960, the Senate Democrats put together a resolution saying that President Eisenhower should make no last year nominations. And in 2007, Senator Schumer even said that he advocated that no Supreme Court justices that are nominated by President Bush during his last 18 months would be confirmed by the democratically controlled Senate.
Okay, so that brings us to the Convention of the States Project. Why do these two fit together? Well, it's simple. There are several reasons. One of them is, among the items being considered for a Convention of the States, the amendments to the Constitution, are term limits to the United States Supreme Court. So that is, if these senators, these Republican senators, happen to buckle to the pressure of Barack Obama and allow him another liberal appointee, if there were term limits and no longer longer a lifetime appointment to the United States Supreme Court. If there were term limits in place, it would limit the damage.
That's absolutely correct. It could mitigate the risk and any damage made by this type of nomination. An amendment could be made under the Convention of States where states could override a Supreme Court decision, or they could make an amendment to limit the terms of the Supreme Court justices, as you said. So a Convention of States can provide that reasonable approach to situations like we have today.
And really, this situation that we're going through right now is making the case for a Convention of the States, an amendment to change the nature of the United States Supreme Court. When they had lifetime appointments, back when the founders were putting this thing together, the Constitution, that is, people were living to the age of 50, maybe 60. Lifetime means a heck of a lot different when you look at Ginsburg, for example. Now, in Ohio, what is the status of your Convention of the States article or bill, or what is the status right now in your legislature?
Right now, House Joint Resolution 3 in Ohio is in the Government Accountability and Oversight Committee. Last week, we had proponent testimony, and we had about 60, 70 people packing the House, where we could have people testifying on behalf of House Joint Resolution 3, the Convention of States resolution in Ohio, that ranged from the ages of high school students for 17 years old to retirees over the age of 70. Next, we'll have opponent testimony coming up soon.
So what do you think the realistic timeline is for it to be brought to a vote and possibly passing?
We're looking for this spring. Of course, the House and the Senate need to do their due diligence through their committees, but we have confidence that we'll have the votes to pass the resolution and have this finished by hopefully mid-spring.
Okay, so big picture here. So far, 5 states have signed on to a Convention of the States, Tennessee being the last one about a month ago. You need 34, according to the Constitution, to sign on to this. Is it realistic that this could happen this year from what you're hearing from the other states?
Absolutely. We've had 7 committees in 7 different states pass our resolution. We have it introduced in, I think, about 24, 25 different states beyond that. Right now, they have active legislation like we have in Ohio. So it's absolutely possible. And I think situations like the death of Justice Scalia and some of the other things that are going on in our system today can really accelerate this process.
In the meantime, we have to put up with the likes of the aforementioned Chuck Schumer, who is a complete and total hypocrite when it comes to the United States Supreme Court. Steve, thank you for joining us.